Good morning everyone and welcome to this month's webinar. And in the lead up to the festive season, we thought that we'll talk to you about managing work-related functions and events. So we're going to guide you through how to organise an event and therefore minimise the risk to your business while still being able to reward your employees and for them to enjoy themselves. Copy of the slides will be sent out in the days after today's event, and there'll be a link to the recording as well, so you can listen back or share with your colleagues. I'm Victoria Templeton, HR Knowledge Manager at HR Solutions, and I'm joined by Sue Watson. Sue's our Operations Director, and together we're going to take you through this topic. We've got so many of you on our webinar today, which is great. We've placed you all on mute. However, as always, we do like to have your involvement in today's webinar. And so we'll do that by inviting you to ask us questions. And the slide now shows you what the GoToWebinar panel looks like. Simply type in your question in the panel and then we'll aim to read out and answer as many as we can at the end of the session. We also like to make our webinars as engaging as possible, and we do this by using polls. So these not only help steer the webinar, but it also allows us to all share how the topic is being managed in our own workplace and can therefore help share ideas of best practice amongst everybody that's on the webinar today. So when you see this slide, we're going to run a poll. They are confidential. We only obviously share and publish the results to the question. So we would welcome as many of you today sharing your insights with us. So this is what we're going to cover today, and it's first of all just establishing when is a social event a work event, because it isn't always clear cut. We're going to look at vicarious liability and what that means. We'll touch on briefly the Equality Act 2010 because that's pivotal to managing work-related social events. And then we're going to look at the Worker Protection Amendment of Equality Act 2010 2024, which has recently come into force, which is also going to be very pivotal to how you manage workplace events. We're then going to look at what our tips are for how you can run a safe and fun event, and whilst at the same time protecting your people and your business. And then, as I said, we'll finish off with taking your questions at the very end. So please do jot those down as we take you through the webinar. And we're just going to begin the webinar with 4 polls, and it's really just to get things going and just to understand what's happening in your workplace. And the first one really is just let us know how you would describe your workplace first of all. Is it micro, small, medium, large? And then that just helps us to steer the webinar as we move forward.
Okay, I think we've got most of those through now.
Thank you.
So there's the split.
Lovely. So most of you, 38% under the 250 bracket. Yeah, okay.
Most in the middle section.
Yeah,
as probably as we would expect.
Yeah,
so
and I think that's useful to know, just because when it comes to talking about reasonableness, very much the organisation, the size and the infrastructure obviously plays a big part in what's reasonable for your business. And then the second poll is about whether you have an event coming up in your organisation. And I'm liking this result that I'm currently seeing at the moment. Oh, it's just switched again. It's good seeing how the results come through. So at one point it was just 100% yes. So the majority of you on this webinar obviously have got something planned in the coming weeks. And that leads us on to the next poll question, and that's around whether do you consider this event to be a work-related one, or is it a social event? And by that I'm meaning it's outside of working hours and also outside the workplace. And then is there a fourth, Sue? 92% Christmas party, which isn't a surprise. And then, yes, this is the question that I just mentioned a moment ago. Do you consider it to be work or social? And as I said, social to be outside of working hours and outside the workplace. Lovely. All pretty much just near half and half. And then the previous percentage was it majority of people with the Christmas party coming up. Okay, lovely. Thank you, Sue. And so we're going to now look at the important consideration is when is a social event, a work event, and those poll questions were there for a reason, because actually it can sometimes be a bit of a tricky one. It's not necessarily clear cut, but there's obviously instances where it is more clear cut. A social event that is carried out in the course of employment can be a work event. And why I say it's not clear cut is because what do we mean course of employment? So it can be your office parties, it can be client functions, it can be work organised social events, it can be post-meeting social drinks. Those examples can be classed as work events, but it's going to be a question of fact for ultimately the tribunal to resolve. Like I say, it isn't always clear cut. I have some case examples that will illustrate this, but thankfully these case rulings do give us that guidance to help us when it comes to planning and managing our own events. So it's going to be down to the tribunal ultimately if the event is considered continuation of employment. And the principles are both in common law, i.e. so case rulings, and discrimination law, such as via the Equality Act, that we will come on to shortly. So here you've got some names of particularly relevant case rulings, so you can go away and have a look at that in further detail. I will touch on them at high level only shortly, but these are all guiding principles for how we need to be mindful of planning our events. So a tribunal will consider the relationship between the parties, as in the employee and the employer, what the connection is between that relationship and any wrongful act that has happened. And then the court will establish if there is sufficient connection between the wrongdoing and the person's employment job role. So I mentioned a few cases. The first one just wanted to highlight is a well-known one, Chief Constable of Lincolnshire Police v Stubbs, and that was where there were allegations of sexual harassment by a fellow police officer, and it occurred when there was several police officers in attendance at a pub social drinks for a leaving party of a colleague. So there were several police officers there. One male officer in particular then subjected a female colleague to several incidences of inappropriate sexual behaviour. So it took place during a social gathering immediately after work, i.e. that was a leaving event. But in this case, the judge ruled that although the social events were away from the workplace, they were considered to be extensions of the workplace, and therefore it did occur during the course of employment. So this is one showing how leaving drinks after work, even though it's not on the work premises, even if it's after hours, can be considered a work matter. And in this case, there was a sufficient connection, as I say, with the employment at the Chief Constable of Lincolnshire Police. Therefore, they were liable. We also have another case in Livesey v Park Merchanting, and this again was a sexual harassment case by a colleague, actually that took place on the way home following a Christmas party, and that was found by the tribunal to be within the course of employment. Bellman versus Northampton recruitment. This was interesting in that it was an impromptu social gathering. So there had already been a Christmas party, but at this impromptu drinks afterwards, it involved there being some work-related discussions taking place between the MD and employees. With one employee in particular, it had turned heated. The MD was lecturing the employees about work matters and trying to assert his or her authority of their seniority within the organisation. They subsequently, the MD lost their temper, became physical, verbally abusive, and it resulted in serious injuries to the employee, to Bellman. And the Court of Appeal in this case found that despite the drinking session being an impromptu drink after the Christmas party, it had actually become an extension of work. And they focused on the fact that it was because of the discussions had turned to work, and the MD was acting in their role because they were asserting their rights and responsibilities as a senior member of the business. So this was a really interesting one. And obviously, when considering in the course of employment, what this shows is employment must be looked at quite broadly. But why does all of this matter? Well, it's because we have legislation in the UK that means employers can be legally held responsible for certain actions of their employees, despite the employer having technically done nothing wrong. It occurs where there is that sufficient connection between the wrongdoing and the employee's employment. And where there is an employer who is found to be legally responsible, they must then compensate the victim for the incident. And you may have heard the phrase vicarious liability, and this is exactly what we mean by this. So these case rulings illustrate that actually away from the workplace, outside of working hours, employers can still be vicariously liable for the actions of their employees, even if they don't know what is happening at that particular moment. So if we think about discrimination, the Equality Act obviously is a legal framework for it, and we have to protect employees from being discriminated against for a protected characteristic. We have to protect people from being harassed, sexually harassed. So in terms of these elements, the actual act itself says that anything that is done by a person in the course of their employment must be treated as also being done by the employer. So that's what I mean when even if the employer doesn't know what's going on at an event, they're still going to be responsible. So it doesn't matter if the wrongdoing is carried out with the employer's approval or principal knowledge. The defence, an employee's defence, must show that they took all reasonable steps to prevent employees carrying out that inappropriate conduct. So if something was to happen, so like in those case rulings we've just gone through, if an employer had carried out various steps, and they're the steps that I'm going to share with you later in the webinar, there probably could have been a different response. So that's why leading up to workplace events, Christmas parties, there is some practicalities that employers need to sort of work through to make sure that they're putting them in the best possible position to prevent risk to their employees, but also from the business point of view. So what the Equality Act also says is that in proceedings against A's employer, who is B, in respect of anything alleged to have been carried out or done by A in the course of their employment, it is a defence for B to show that they had taken all reasonable steps to prevent A from doing that wrongdoing, essentially. And as I said, we'll come on in a moment to looking at what those practical steps could be. If we think about the Worker Protection Amendment of the Equality Act 2024, this came into force 3 weeks ago, and it makes changes to the Equality Act. And what it has done is to provide or place a new legal duty on employers to take reasonable steps to prevent sexual harassment from occurring during the course of employment. And what this means is that when a claim of sexual harassment has been upheld at tribunal, the tribunal will have authority to make an uplift of up to 25% in the compensation that is paid to the employee or worker. It is also given greater powers to the Equality and Human Rights Commission, the ECHR, in order for them to enforce this new duty. But what I wanted to emphasise is the current legal position is it's for an employer to take reasonable steps, and not all reasonable steps. There is a really clear difference. So at the moment, the duty for yourselves, your organisations, is to take those reasonable steps. But I do need to highlight that the Employment Rights Bill of 2024 that came out about a month ago, that proposes to extend this, and actually at some point in the future it will become most likely a duty where all reasonable steps must be taken. So clearly this new legal duty is relevant to the festive season, because employers must be considering what reasonable steps they need to be taking to comply with this new legal obligation for when they're managing their coming up Christmas parties. So clearly, first of all, the context in which organisations operate is important, because what is reasonable will be fact specific. And like I hinted to on one of the polls, the larger the organisation, I guess the harder it is to say something wasn't reasonable. The smaller organisations, obviously, with limited resources, structure, etc., it could perhaps make it harder to do certain things. But let's look at some of the practical tips. And these tips here are for essentially preventing sexual harassment in the workplace. We've got some further suggestions on general tips for managing workplace events. Now you'll notice that many of these are fairly obvious, and most likely you'll be doing these anyway. But if we just go through them, and I'd say the first important piece is around the risk assessment. Having a specific risk assessment that prevents sexual harassment taking place is vital. The ECHR recommends and advises this is introduced. It's part of their code of practice, and they also advise having an action plan and monitoring that action plan. And I suppose this is essential, because if you don't identify the risks, how do you know what is a reasonable step to take or what action to take for preventing sexual harassment? And so with that new duty that's now on the place of an employer to prevent, that is going to be central to what you then determine as to what's reasonable. Reasonable steps also include being prompt in how you deal with complaints, because, well, I guess, you know, if there isn't that prompt, swift response, what's to say, you know, it could carry on and continue with other individuals. So you're not preventing it generally. So you've got to be prompt, and obviously that falls in line with the ACAS codes that we have in place for disciplinaries and grievances. A reasonable step, reasonableness is also about proper and thorough investigations, taking appropriate actions. So if you if there are instances of sexual harassment, then it's about how you then prevent it from happening again, and that's where your disciplinary framework comes in place, because you've got to be addressing those claims. Having anti-harassment policies in place is critical, that are well communicated well throughout the organisation. You might call your policies your bullying and harassment policy, but nevertheless there needs to be a clear framework in place for how you deal with allegations, the fact that you don't tolerate it, zero tolerance in the workplace, and having a clear statement that sexual harassment isn't going to be tolerated, it's unlawful and may lead to disciplinary action up to and including dismissal, is all key and vital communication messages. It's also important to acknowledge that, and I suppose build into your risk assessment aggravating factors. So, you know, could there be abuse of power over more junior colleagues? You know, that needs to be factored into your disciplinary process, to your risk assessment. Your policy around sexual harassment should include clear examples that are relevant to your working environment, because then it's easier for employees to really understand what do we mean by the different forms of bullying and harassment and discrimination that can take place. It's vital as well to have effective procedures for receiving and responding to complaints. including third-party harassment. Now, this all came in again with this new duty about 3 weeks ago, in that reasonable steps will extend to putting measures in place to prevent third-party harassment. So letting clients, customers know it's not tolerated. It's about having measures in place. Might be you might need to have posters dotted around. If it's a contact centre environment, having a message at the beginning of the call when they phone in. So it's just looking at what measures you can put in place to prevent sexual harassment from taking place. And of course, as I said, in the lead up to Christmas events, where alcohol is flowing, you may be in public settings with large numbers of people who are also under the influence. You know, risks generally increase in that kind of environment. And so it's really, really important that carrying out risk assessments, in particular to the event, is going to be important. So just on that, and if we just still focus on the sexual harassment piece, just a quick poll, and it's just trying to understand really what steps have you taken already to ensure sexual harassment is prevented at work, but also during the course of employment. And I think this should be a multiple choice.
Just leave it a couple more minutes, seconds, I mean.
Brilliant. So good to see they've all been actioned to varying levels. The risk assessment, as I said, that is going to be fundamental, because it comes back to how do you know that the measures you have in place are reasonable and they're directed specifically at preventing sexual harassment. So for those of you that haven't undertaken a risk assessment, that's something that I definitely urge you to sort of go away and develop. We do have a template available on our doc shop, which you can go and have a look at. That's available through our main website. The action plan is also something that the ECHR advise alongside the risk assessment. So once you've completed your risk assessment and you've identified where those risks are, the extent of the risk and the measures, there's that requirement to then have a practical plan in place that helps you to either basically remove that risk or reduce that risk significantly. Sometimes you can't take the risk away. For example, you know, you might be a pub where you can't take the risk away completely because, you know, there's too many factors that are involved in that setting, you know, with, you know, large groups, members of the public, alcohol being served, etc., etc. But definitely also then follow up your risk assessment with an action plan. And again, we've got a template on our doc shop. It's good to see that most of you have updated your bullying and harassment policy. That's critical. And even though that, you know, you will have already had one anyway, because of the new duty, there's that requirement to make it more robust so that you are conforming to this new duty. Brilliant, thank you. So those previous suggestions were more about specifically to that new duty, but if we think more broadly about planning work events, social events, and it doesn't need to just apply to Christmas parties, but, you know, as we know from case rulings, if it's somebody's leaving do, even if you're going to your employees are going to conferences off site, or, you know, something, a function where there's that continuation of employment, there's that sufficient connection to employment. These are tips that can help support in planning a safe and fun event. And the first and most important one is your risk assessment. So that's a key duty. risks must be assessed in advance. It allows you to identify where the risks are, the extent of the risk, and to put in place the measures to either remove or reduce the risk. Now, the general risk assessment is very different to a specific one dedicated for preventing sexual harassment. So your general risk assessment is about, you know, the venue that you're going to, and just what facilities you're putting on in terms of alcohol, any vulnerable employees, etc. So it should be carried out in addition to your sexual harassment prevention risk assessment as well. Then in terms of having a person or two managers in charge is also important for the prevention of any incident. So ensure that somebody in authority remains sober, is able to take charge if necessary. Managers should be reminded that they are also responsible for setting and upholding standards and should intervene. Do you remember? So remember, you know, your policies and procedures will continue to apply. So if there is behaviour that seems to be bordering on the unprofessional or unacceptable, they need to be able to, somebody needs to be able to step in. And so it's thinking about who in the organisation in the position of responsibility can be a point of being someone in charge during the event. In terms of briefing your managers in advance, that is also obviously going to be key. And it's just letting them know about keeping an eye open for any signs of harassment or unacceptable behaviours, because they need to be able to nip it into the bud. Normal rules of conduct and behaviour apply. So, for example, you know, the presence of mistletoe does not give people free rein to inappropriate behaviours. So it's about reminding managers of your bullying and harassment policy, your disciplinary policy, because after the event, if there has been any unacceptable behaviours or complaints, then they need to be managing the issue under that disciplinary framework, or there may be some grievances raised in which they need to be managing. Probably another suggestion is remind your managers not to discuss work-related issues. And I think that case ruling that I went through a moment ago is probably a good one to highlight why. So avoid talking about performance, promotion, career prospects, salary increases, because conversations could turn quite easily. Shortly before the day, your managers can then remind your employees of the expected standards of behaviour and any related HR policies. You may have a drugs and alcohol policy. You might, hopefully you'll have an equal ops and a harassment policy. So making sure that they know that they still remain in place and in force. But it's about, you know, letting them know you don't want to be the killjoy, but normal standards of behaviour apply. And I think a really, really important step is an all staff memo. And I know it's really hard to not come across as being a killjoy, but actually this is a really, really important measure. So it's about ensuring that everyone is reminded in advance that the event is a work event, and therefore everyone continues to be held to the same standards in the workplace. It's also important to reiterate the company's position on zero tolerance approach to any kinds of breaches of the policies, and that they'll be addressed afterwards under the disciplinary process. I think it's really important in writing, especially because it's a further illustration of you taking the necessary practical steps to prevent harassment, discrimination, physical or verbal violence. I know that it can be hard to seem like you're not a killjoy, but it's about how you word your memo in a way that gets the message across, but it still conveys that you want people to enjoy themselves. I do know that if you are a client of ours, or even if you have access to our knowledge base, either our consultants or helpline team can help you with the guidance, and we actually have an example of a template that you may find helpful, and we'll have that on our knowledge base as well. And then in terms of inclusivity, this is really important as well, because you need to be considering the type of event and the venue to encourage as many people to attend as possible. So, for example, you need to be remembering to invite those who are out of the business on long-term absence, so those on maternity leave, adoption leave, or even like long-term sick, and don't assume that they won't be able to attend. When it comes to sickness, that could probably be a little bit tricky to get your head around as to, well, if they can't come to work, why can they come to a party? Well, just because somebody is declared unfit to be able to carry out their work, the nature of their absence may not mean that they cannot attend work events and functions. So you don't want to be accused of excluding people, and because, you know, where that reason for the exclusion is because of a protected characteristic like disability, sex, pregnancy, maternity, that's where you are on dodgy grounds with claims. And then alcohol as well. This is another consideration from an inclusivity point of view, the use of alcohol. Remember, you want as many people to be attending as possible. When it comes to organising a work social event, consider not all employees will want alcohol. You need to consider as well religious beliefs. You know, Muslim employees do not drink alcohol because it's forbidden. There could be employees who don't drink alcohol because perhaps they may come from a family where alcohol has been abused in the past, or it has been associated with violence. You could also have employees there who are under the age of 18, or who have a problem with alcohol as well. So it's really tricky, but it's just giving careful consideration to how you manage that. And especially, like I've mentioned, with the prevention of sexual harassment, you know, risks increase when alcohol is around. And so really there's going to be a need to carefully think about how you're going to manage that as best you can. So, for example, instead of offering a free bar all evening, you could just limit it to your first 2 drinks or drink on arrival. Or, you know, making sure that you're offering not just alcohol, there's soft drinks as well. And similarly with food, again, from an inclusivity perspective, if you're offering food, then consider whether you can have food alternatives to meet the needs of various religions that are observed, people who are vegetarian, as well as people that may have allergies as well. So it's making sure that the food that you're choosing as well for your event is accommodating and inclusive for everybody. And also the same for entertainment. You need to take care in planning what sort of entertainment you have to ensure that it doesn't cause offence. So you don't want to end up with any discrimination claim, you know, because of jokes that have been told. It's about trying to work out what is appropriate entertainment for the workplace. And then other considerations that are really important is about getting home. And again, like we found out in that earlier case ruling where sexual harassment took place in taxi on the way home, if the event involves drinking alcohol, or if it's an evening event, encourage your employees to find suitable methods of getting home, perhaps together, using a variety of ways. You could even look at a shared minibus. As a minimum, ensure that you have contact numbers of taxis that can be in place. Because obviously there's that responsibility of ensuring your employees travel home safely at the time that your event ends. And remember, your duty of care towards your employees extends to a work-related social event. So employees can still be vicariously liable after the party has finished. Another consideration is the next day. So this obviously is more relevant to those that operate 7 days a week. So if you don't operate on weekends, then you may be able to avoid the potential problem of lateness, incapability the following day. But obviously if you can't do that because you do operate 7 days a week, then consider how lenient you might want to be towards staff who turn up late, with a headache, or even how you deal with those sickness absences. Ensure that all managers take a similar stance, so otherwise you might end up with grievances and consistent disciplinary warnings. So you've got to have an agreed upfront approach to how lenient you want to be the next morning. And then be especially careful if you're an environment where you're operating machinery, then it's about making sure employees who drive or operate machinery are fit to do so. And then consider what the likely chances are of unexpected absences or lateness and how you might cope with those. How are you going to deal with organising extra cover, etc. And then the aftermath. If you do receive any complaints of well, anything but harassment, discrimination that has resulted from a business organised event, then take them very seriously. Complaints need to be dealt with in accordance with your appropriate procedures and as quickly as possible, particularly because memories can fade. But you need to make sure that you follow up with complaints that occur at social events. So whilst they might not be taking place during the working hours or during the workplace, as we've seen through these slides and the case rulings, clearly there can still be a sufficient link to employment, and therefore you're obliged to, you'll be potentially liable. So before we take questions, I just wanted to highlight what we offer in terms of the new legal duty to prevent sexual harassment. So first of all, we have a new online free risk audit. So that's a 10-minute questionnaire audit that you can carry out, and it will identify perhaps where there may be gaps so that you can then put actions in place to make sure that you're taking the reasonable steps you need to comply with that duty. We have a detailed risk assessment template and action plan on our doc shop. Obviously, we offer line management and employee training tailored to your business. We have an updated new bullying and harassment policy, also our disciplinary policy, because what you need to consider is that it's not just your bullying and harassment policy that needs to change. You need to make sure that they are aligned to all other working policies that you have in place. And then there's that free 30-minute call with one of our advisors as well that we've put on to support that employers with this new change. So Sue, have we had any questions?
So we've got, excuse me, one question just around the third party piece.
Okay.
That's the one they're finding the hardest and wondering what options there are for managing that.
Okay. I mean, do you want to go? Have you got thoughts or?
I guess I think it all boils down to what you talked about the risk assessment and the action plan, and identifying where there is, because it's not just Christmas, I guess we're talking about here. This is any sort of any situation, any event. And if you've identified that there is a risk from third parties, and it's what action you can take to minimise that risk. At Christmas events, obviously there's a very well-known case about third-party harassment in the past, and that is through close management. I think that's where your managers come in, isn't it? In terms of they need to make sure they keep an eye on their teams that are there, because you can't try and keep an eye on everybody in a room is impossible. But you could ask all your managers to make sure they keep a close eye on their staff, which is why they need to stay pretty compass mentis in order to be able to keep an eye on things. And I think encouraging staff to, if they do find themselves in an uncomfortable situation, to have a process in place that they can raise an alarm, whether it's been, excuse me, by texting somebody or by alerting it to another member of staff who's nearby, so that they know there's a protocol in place. If somebody says a particular word or something, a bit like we have in some pubs, I think there's a word you can say, isn't there, to the bar if you are concerned. I think you might need to consider, do you need to do that? So I guess it's just considering where the third party interaction is and whether there's anything you can do to just make staff have a route to go through if they need to, if anything happens.
Yeah,
And you can't predict everything, but you can sort of
it's
consider
about
from
what's
previous
believing.
experience where are the risk areas and what can you do to mitigate it.
Yeah, and I
We've had sorry, we've had a couple more questions come in since then.
okay.
If someone made a complaint about a third party, we'll stick with the third party for a minute. Who would investigate it? Is it you as the HR team of the employee or the HR team of the third party?
So so you would have an obligation to follow up with your own internal procedures and do your investigations. You would need, depending on who this third party is, but say it's an agency worker. So obviously you would need to work with the agency as well to be able to feed in the input and the response to any issue that has happened, so that your investigation isn't just one-sided listening to the employee, but you're getting an all-round view of what has happened. For the agency, they would have obligations themselves for their to ensure that they are following their duties in dealing with issues. And correct me if I'm wrong, Sue, but tribunal claims can be dual in that you can have a claim against your employer and another employer, an agency.
Yes. Yeah, if they haven't followed, if either party haven't followed their own processes properly, then yes, you can essentially bring both. But whoever's the employer or the contractor of the third party, then they need to handle that through their own processes. So if it was a contractor or if it was an employee, if it's an employee, they'd have to follow their own disciplinary procedure, investigate and potentially discipline. But you would be raising a complaint if it was a provider of services to you with that provider and potentially, no longer using that provider. And that would be potentially one of the actions that you would take to protect the employee and obviously putting in some support for them, etc. But you have to treat each case, it depends. But definitely you would need to do your own investigation to understand fully what happened from your side and then speak to the third party to find out what they're going to do about it and what they found from their side, and then you come to an agreement as to how you take it forward between you. So another question was, do we have to consider including dress code disclaimers in a memo for all staff? And if so, how best to phrase it? I think Victoria's having a problem with her headset at the moment. So I think possibly if that could be an issue, it's a delicate one. You need to be careful that you don't sort of cause more problems by raising the issue. But you could have, I don't know if you've got a theme, you could use that, or if you're wanting to dress to impress, or if it's formal wear, or if it's casual. If you have a dress code within the workplace, then do you want to extend that to the social evening? It depends very much on what you're doing, but it is something you have to consider, and you potentially might need to, but you'd have to make sure it wasn't exclusive the way you worded it, so that you weren't there wasn't any issue with maybe religious dress and things like that. So but like any dress code in the workplace, you would need to consider how you did that. Another question is around anonymous reporting, but how is it helpful if you don't know who is making the complaint and what exactly it is about? I think you have, depending on how you receive the anonymous notification, you have to do what you can to try and speak to them directly, because you can't really take it forward unless you've got any foundation for it, because otherwise how can you be sure that it's justified? and that it's not somebody else trying to stir things up. So unless you can actually qualify the complaint or the report, then you will have difficulty in following that through. But you have to maybe try and find out from any other, if you're aware of the circumstance, maybe see any other witnesses to anything that might have happened on that day or at that time or in that place. And therefore, if you'd be grateful if anybody does have any information, that they would step forward and talk to you confidentially about it. So, so that's really yeah, very dependent on circumstance as well. I think that's all the questions. Thank you. Do we have Victoria back, or no? Doesn't sound like it. Okay. So the next few slides, excuse me, are just to talk a little bit about some of the information and some of the resources that that we have that you might be interested in, that might help you with this. So we do have a knowledge base that gives you loads of template HR documents and policies, articles and guides, as well as some guidance on a wide range of topics and some examples, things like this. There'll be some examples of situations and also some case law that you might find useful to back up any of the queries that you have. We also are running a number of training courses, including around the sexual harassment. So if you are interested, then just let us know. We'll give you there's a poll coming up in a minute if you want us to contact you about it, but you can find it on our website as well, more information, and there's a contact us form through that as well. This is our forthcoming webinar schedule. We've got the very popular Year Ahead one in December next month. We've got a lot of people already registered for that one, so if you haven't already, do book your place. We're going to talk about all the things that are going on at the moment, which is quite a lot for those of us involved in HR policies, managing staff. And then in January, we're going to focus down on the SME sector, so all the essentials you need to have in place, and all the things that are particularly pertinent for small employers, especially at the very small end. So if you're a startup or just taking on your first staff, we'll be covering all the things you need to do and in what timescale. But also for those larger small employers, we'll be covering, again, everything that you need to make sure that's in place, just to make sure that that you're fully compliant. And then we're going to start looking, we're hoping by February we'll start getting some more information about the Employment Rights Bill. So we're going to deal with it in sections, because there's quite a lot of it that's coming through. And so we're going to focus initially on the pay implications. So we know we've got quite a lot of changes with the National Minimum Wage, but we're going to look at the wider pay implications of the Employment Rights Bill, and help you hopefully to start everything before you finalise all your New Year budgets and things like that. And then we have our ever popular virtual employment law seminar in March. That's on the 6th of March, and so do save your place for that. It also has a huge following, so hopefully by then as well we'll have lots more consolidation on the Employment Rights Bill, so we'll be able to update you on that, but also on some interesting cases which can help with managing staff and help you enforce your policies, and hopefully bring you all up to speed on anything employment law. We have got a programme following that, but we're still working on the topics to finalise them, so please do let us know if there's anything particular you would like us to cover, so that we can take that into consideration. So we have got a series of audits on our website, on our main website. There's a QR code there that you can get straight to it. So there's a general one where you can uncover potential risks to your business, and then you get a comprehensive report straight away at the end of it that you can download, and it'll give you a RAG rating depending on your answers as to things to focus on in particular in the coming months, and we can obviously help you if you need any support with that. The other thing, as Victoria spoke about earlier, we are offering a free 30-minute consultation with one of our advisors. to give you a flavour as to what we are like. And you can be, it doesn't matter if you're an HR person, you just want a sounding board. You can be a line manager, you can be just a team manager, supervisor, whatever context you are in. If you would like to try us out, then just fill in one of our forms or use the QR code, and they will reach out to arrange a time to talk it through with you. I've talked about that one. This is the upcoming one this next month on the HR year ahead. So do sign up there. And as always, keep in touch with us. There are several routes there, through our website, through our main line, phone line, or through our inquiries email. Finally, just to remind those of you who are new to us today, we do have a free HR white paper available on our doc shop and through the QR code, which is covering a range of sort of business challenges and business forward-thinking strategies, which you might find useful if you're trying to find a way forward. And then finally, we have one more poll just to ask if you would like us to contact you about any of our services. Just let us know. You can either do it directly through here, or you can contact us directly separately. Okay, I will close that now. All it remains for me to say is to say thank you to you all. Thank you for attending. Thank you very much to Victoria. I'm really sorry we lost her partway through there, but I know she'd be thanking you as well. And but we hope to see you soon, and we'll resolve all our technical challenges by the next one as well. So thank you very much.